showtime. Welcome to the show. I'm Brent Holland, and welcome one and all. Get in your most comfy chair. We've got a great guest for you tonight. Get the coffee going, get the tea going, get a beverage of choice going. Kick your feet back up. Take this time for yourself. We're going to talk about the JFK assassination tonight with our guest, Andrew Eiler. We're going to look at different aspects of when he went to the archives in Washington, D.C. I want to welcome you to the show, Andrew.
Well, good evening, Brent. Thanks for having me on the show. Like I said, I've been a long-time listener, and I'm really pleased that you've invited me on. As a lawyer, I mean, I've been fascinated with the legal aspect of the JFK case. Evidence is what most people are dragged into this story, whether it's the magic bullet or the cast of characters and witnesses and the investigations. It's pretty interesting for anyone. But my real focus for the last 5 or 6 years has been on the JFK Records Act, and like a lot of people, I first got interested after Oliver Stone's JFK, that final scene in the courtroom with Kevin Costner playing Jim Garrison, and he looks directly into the camera, kind of breaks the fourth wall, and he says, "It's up to you." And then they show the screen with the fact that there are tens of thousands of files being withheld in secret about the assassination, and that they won't be released until 2029. Now, that's only 4 years from now, but back then, that was 40 years. And I mean, that seemed quite shocking to me. So I started to do a lot more reading after that. And when they passed the JFK Records Act, I still hadn't started law school, but I I made a copy of the JFK Records Act, and I started reading it even in the 1990s. And as the statutory deadline of October 26, 2017 came along, I pulled that copy of the JFK Records Act out of my files and I started to study it again. And
What stood out to you that wasn't right? By the way, folks, if you're just joining us, we're
it's okay.
speaking with Andrew Eiler tonight. He's got a new book out that's co-authored with James DiEugenio, and of course, Paul Blow was on the show. And the book is called The JFK Assassination Chokeholds. I urge you all to get it. It brings forth new information that we were unaware of before. Now, back to Andrew. Andrew, what was it about reading those records that stood out to you and said, hey, this isn't copacetic. This doesn't make sense?
Well, the law specifically says that on October 26, 2017, that the remaining records that are being held in secret by archives are to be fully disclosed to the public. There are exceptions to that, and but the exceptions are very, very narrow. And so the expectation was that tens of thousands of records that no one had ever seen before would be released to the public. And when that didn't happen, and there was a kind of wholesale further postponement right on the eve of October 26, 2017, you could just feel a palpable sense that once again, something wrong had happened. And I think the public reacted to it. There was a great expectation, and even President Trump at the time was tweeting all about the fact that he was going to release all the records. And I think most of America felt like there was a bit of a rug pull when those records weren't released. And that's when I really, really dug into the act. And I'd been a practicing lawyer for over 15 years at the time. And I felt that I should do something about it. So I reached out and contacted some of the lawyers down in the U.S. that were working on trying to do something legally to enforce the act, and I ended up doing a considerable amount of research and drafting on a lawsuit that ended up getting filed in the courts in California against President Biden and the National Archives. So now I'll be clear, I'm not part of that project. I stepped away from that project a couple of years ago, but I've continued to, in my own way, pursue the release of these files in accordance with the JFK Records Act.
How does that work being a Canadian lawyer? Apparently, folks have just learned that we no longer have attorneys, never had attorneys in Canada, but we have lawyers having some fun at Andrew's expense, I'm afraid. How does that work as a Canadian? Do you get access the same way that an American attorney would?
Well, I certainly can't practice law in
Right.
the United States without a license. A lot of the principles that impact the JFK Records Act come from common law, which is a shared kind of law that both Canada and the U.S. inherited from England. Principles like mandamus, judicial review have very similar authorities, and so the concepts are very familiar, whether you're a U.S. lawyer or a Canadian lawyer. Um, so the what I brought was a lot of experience in administrative law, and and so that's what I put my effort and energy into is developing the cases and studying the U.S. authorities that prevail in those areas. And
Okay.
yeah, but certainly I couldn't be in at the table in the courtroom in that case. But I developed a pretty extensive knowledge of the JFK Records Act and other surrounding legal issues like ministerial duties and discretionary duties of officials under legislation in the U.S. So the work that I ended up doing caught the attention of a few lawyers and Jim D'Eugenio, and they asked me to take part in writing the JFK assassination chokeholds, which was an awesome experience. I've got to
Mm.
say the book is I enjoyed my parts in the book, and man, the other authors did some superb work on those 10 chapters. My area is mainly focused on the legal aspects of the investigations, and I wrote a good chunk of the introduction of the book that really focused on standards of proof and how the Warren Commission and the House Select Committee on Assassinations they kind of gave lip service to having a standard of proof from their investigations, but they didn't adhere to any standard of proof, which really allowed all of their findings and conclusions to be made arbitrarily, not based on principles of evidence and not held to any level of standard of proof. And
So at the very end of that, then let's take the House Select Committee on Assassinations, which folks I think ran from 1977 to 79. Their conclusion at the end, just to let you know, was that they felt that there was a conspiracy to kill President Kennedy. Now, I'm just wondering if they base their evidence on something that isn't quite as meticulous in terms of law as you would expect. What are we looking at then for evidence? Is it mostly hearsay, in your opinion, or is it mostly something that may have come by the by?
yeah,
There's a Newfie expression, eh?
Brent, I was actually surprised when I realized that there were no standards of proof applied in either the Warren Commission or the House Select Committee's investigation. That the
Unbelievable.
whole point of having a standard of proof is that yeah, there's a bar in civil cases, preponderance of evidence or balance of probabilities, you got to get over that bar in order to find liability. And in criminal cases, the beyond a reasonable doubt standard of proof is a very, very high standard. And if you're going to find someone guilty of a crime, especially a crime like murder or some other capital crime where the penalty is life in prison, or even the death penalty down in the US,
Mhm.
that bar is extremely high that an adjudicative body has to overcome in order to have a finding of guilt. And really, what you see in the Warren Commission is, yes, they allowed hearsay. Yes, they didn't allow cross-examination of their witnesses.
Can you give us an example of where they fell short, the Warren Commission? And I'll ask you the same question for the House Select Committee on Assassinations as well.
Yeah, in the Warren Commission's final report, they talk about standards of proof, but then they go on to say, well, this isn't a court of law. This is
Mm.
a fact-finding commission. And so what we want to do is we want to try to get to the bottom of this. But they really didn't. They excluded witnesses. The witnesses that they did have were only led through their testimony on direct examination for the most part. All of the hearings, save for and except a few, were done in private. They were secret meetings of the commission. There was no defense attorney that was allowed wide-ranging cross-examination. So the witnesses could be corralled to provide the testimony that suited the Warren Commission's end outcome. And without that cross-examination, it's really problematic. The findings that ended up being on the record, and I
Because
think,
you can lead your witness down a road that you have paved for your own perspective, your own thoughts on the assassination.
and that's exactly what they did.
Yeah.
And the introduction to chokeholds kind of sets out the standard of proof. There are really three standards of proof. I don't want to get too legal here.
No, go
The
ahead.
the lowest one is the civil standard of preponderance of evidence. That's you got to basically prove your case 50 plus one. The high standard is the criminal standard beyond a reasonable doubt, and that's an extremely high standard. The one that we kind of wanted to establish for the chokeholds, the 10 chapters in chokeholds, was clear and convincing evidence, which kind of falls somewhere in between the civil standard of preponderance of evidence and the criminal standard of beyond a reasonable doubt. So the authors of the book really held themselves to account on getting that clear and convincing evidence either of a conspiracy, and in terms of Oswald's culpability for the assassination, we tried to even go beyond that, to show that there was no possible way, even on a criminal standard, that Oswald would be found guilty. And so that introductory chapter kind of sets out the rest of the chapters, whether it's the chapter on Oswald impersonations, whether it's on the evidence of a front shot. And then the last chapter, I think, really ties a lot of it together. And Paul Blow deserves an awful lot of credit for that last chapter. It's titled 60 Years of Obstruction of
Mm.
Justice. And what we ended up doing, the week of November the 19th, was going down to Washington and to College Park, Maryland, where the National Archives are located. And we kind of furthered that final chapter of chokeholds, in terms of looking at obstruction of justice when we really were digging deep into the final orders of the Assassination Records Review Board.
Can you expand on that a little bit?
Yeah, certainly. So when the JFK Records Act was passed in 1992, they created
Because of
and
Oliver Stone's movie, by the way, folks. There was such an
yes,
uproar about Oliver Stone's JFK movie, and I think it's one of the most important films of all time, if not the most important, because it actually raised awareness of the Kennedy assassination to the point where the government was forced to take action and tell some of the truth behind the
it,
story. So
very
kudos.
few films have had that kind of political impact, and I would agree
Yeah,
with you.
I can't think of any
Uh,
other.
Regardless of the criticism, I don't think any of the critics could deny the fact that that movie has caused the release of hundreds of
Yeah.
absolutely critical files that really expose a different light on American history.
And it certainly is, folks, a cinematic masterpiece. If you're studying film, of course, Oliver Stone's own voice is going to come up, but man, that film is just a masterpiece.
I just
Absolutely
watched it maybe about
flawlessly.
4 or 5 months ago, and you know what? It really
Still
holds
holds
up.
up. Yep,
It's a great
I
film.
agree with you completely. Sorry to interrupt you. Let's go back to the archives.
Sure. When they passed the act in 1992, the act created the Assassination Records Review Board, which was an independent agency tasked to obtain all of the assassination records out of government agencies, review them, process them, catalog them, and ultimately release all of the assassination records to the American public. And the ARRB, it formed in 1994 and it ran until the end of September of 1998. And during that period of time, they processed millions of assassination records. And part of their process, they were mandated under a section of the Act to issue a final agency order with respect to every single record that they processed, and they were essentially disposition orders, like a court order, but for every single record. So it's like an impressive amount of work that the ARRB did, and in fact, they issued probably well over 130,000 what are called final determination notifications for the records that ended up being postponed from public disclosure.
I see.
And it was those particular records that Paul Blow, Jeff Crudell, and myself headed to the National Archives to copy, because each one of these final agency orders, um, it 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 provides a release date for
Hmm.
the record or a review date. It also shows the specific reasons under Section 6 why each record was allowed to be withheld from the public. Um, but what we were most interested in is what the ARRB actually indicated for each of these records in terms of a release date or review date, because most of the JFK research community, they know that these records were withheld. They have serious questions about what were the reasons for further postponements, but they don't know why um, or how these records were postponed from public disclosure. And the fact is that all of those reasons are in these final determination forms. Now, Brent, the real problem
There's
is that,
stacks and stacks, right?
well, none these forms are assassination records. They're held by National Archives, but they're not cataloged because they're internal ARRB forms. They've never really been digitized and included in the collection. They don't have what's called a RIF number, a record identification number. And so they've kind of fallen through the cracks, even though they are the single most important collection of records that the ARRB created. And really, they're the basis for all of the ARRB's decisions with regard to each record. And the fact that you can't search them, you can't see them, and even when you go to the archives, it's almost impossible to pull them because apparently they don't know where most of them are.
So let
Um,
me ask you this then. You said that these offer the reasons why these papers weren't released. Can you tell us why they weren't released? Why is it we were always given the excuse that it's national security for years and years and years.
right.
Is that true?
Yeah, so we were able to obtain copies of only 500 of these final determination forms.
Only 500 to go
Yeah,
through.
and there
Okay.
should be 130, 150,000 of these easily. And we were only able to access 500 of them. And so I don't want to get too much into the law, Brent, because people will just glaze over. But Section 6 of the Act is perhaps the most important section of the Act. It sets out five standards or criteria for the government to be allowed to postpone the release of a record. And there are like Section 6, 61A is a record would disclose the identity of a government asset or a CIA asset or employee. And so if that employee is still alive or would be at risk or would put um, an operation at risk, like a current operation, then under 61A, the government could properly
Okay.
withhold that record. 1B is a different standard, and that is a source or method that is currently being used by an agency. The government could rightfully and properly withhold the disclosure of that kind of record, as long as it was current. Um, so what we saw in the 500 records that we obtained copies of is a lot of the postponements were based on either the identity of a living asset or agent or employee of an agency like the CIA, or a currently used source or method. And a lot of those current sources or methods have to do with like um, a foreign asset or agency that the CIA had an arrangement with.
Understood.
Um,
Okay. So there is
but
some merit to that excuse.
well,
But
there
but
used to be. There used to be, okay?
okay.
And that's the thing. The really key aspect of these final determination forms are the release dates that the ARRB ordered. And for I would say a good 85% of the records that were covered under the 500 samples that we obtained, the ARRB ordered these records released in 2000 or 2006. So that's a long time ago.
Yeah,
And right now,
20
what
years.
a team of researchers is doing is they're analyzing the uh, the final determination forms of the ARRB, and they're actually seeing when these records were released. We believe we found several dozen records that are unaccounted for or are still being withheld by the government, despite the fact that the ARRB had released these documents in 2006.
The
So,
book is called The JFK Assassination Chokeholds. Andrew Eiler has been our guest tonight. He is co-author, of course, with Professor Paul Blow, as you folks who watch the show regularly will know. He's been on before talking about the book, and it's also Oliver Stone wrote the foreword for it, and James Diogenio, who's been on the show I don't know how many times, umpteen times, anyways. I've learned a lot tonight, especially the fact that we don't have attorneys in Canada. I'm going to arc back to this little giggle. And we only have lawyers. So there you go. Don't come up here and want to be an attorney. You can be a lawyer, but no attorney, and you have to wear a frock. That's the way it is in Canada. And don't you forget it. And I want to thank you so much for coming on the show. And I have to tell you, folks, Andrew is suffering horribly with a fever. He's got COVID, but you're safe, folks, because I've worn a mask. So you won't get it from me.
Brent, if I can just add
Please do.
one more thing before we sign off. We just released the Audible or audio book for chokeholds,
Muzzle tough.
and so that just became available last week. And also we run a pretty extensive website at jfkchokeholds.com, and we regularly update our findings and research on Twitter at JFK Chokehold. So if your audience wants to follow anything that we're doing, and really we are breaking new ground with a lot of our research, we invite your listeners and viewers to check us out on JFK Chokeholds on X or Twitter.
And I'd like you to, I made the same offer to Paul. I'd like you to check in from time to time and let me know what your latest research shows. And I would like to have you on and explain that to our audience because, it's a targeted audience for sure.
I'd be happy to, and I know the other authors would as well.
Yeah. It's a real pleasure to have you on today and take care of yourself. Chicken soup, they say. I don't know. Never worked for me when I had COVID. I was just laid out, baby. Holy cow. Never been
Hopefully,
so
I'm on the
sick.
upswing.
I think you are. If you can do a show like this, holy cow. Yeah, I'm very
Excellent.
impressed. I'm very impressed. And go Tiger Cats. He's in Hamilton. And Canadian fans will know what that means for sure. I'm Brent Holland from The Brent Holland Show. Look after everybody out there, folks. Everybody's hurting. You take care of yourselves. See you next time.